Welcome back, everyone. This is part 2 of the seminar that I shot in 2013, and the speaker in this one will be Graham Dent. Now, Graham Dent is a prosecutor. Well, he has been a prosecutor, and he gives his view from the legal side of things in respect to industrial safety. I still think this is as relevant today as it was when this was recorded, and I think it's very important. So I really hope you enjoy it. Thank you very much.
All right, my name is Graham Dent. You might have seen the material that Murray sent round. I've been in this area about 30 years. Knew Jim from back in the Department of Labour days. So I started there back about 1980 doing prosecutions, and I've been with a couple of law firms since then, and I specialise in the occupational health and safety area. In today's session, I was going to give you a bit of an overview of the harmonised laws and its impact on you and on the plant safety issues. Now, some of you may figure you're based in Victoria, which hasn't gone ahead with the laws, so how does it apply to you? And there are a number of ways it can impact you. So who's based in Victoria, or business is solely based in Victoria? Do you do any trading or work interstate?
Some just supplying.
Okay. Supplying can still be important. What about yourself? Okay. It's important to understand how the laws work, because you can get caught out by them, and the laws that have changed are quite significant, and so are the penalties, and so are the powers that the authorities have in relation to them. So, which way we go? What I was going to talk about was some of the problems that have arisen for businesses, and obviously with a focus on the plant safety side. Whoop. Sorry, get myself right. Harmonised laws were supposed to cure a lot of problems in Australia. The idea that you could be able to refer to one section of an act, it would be the same section, the same definitions, the same approach, the same codes of practice in every jurisdiction, sounded too good to be true, and unfortunately that's the way it's turned out. So, you know, the process has been going for many years now, and we've only partly got there. So there's 7 out of the 9 jurisdictions in Australia have picked up the harmonised laws, but even there are still some variations. Some of those variations were anticipated to take account of jurisdictional variations with different courts, different regulator names and so on. Others have been where some of the authorities have tinkered at the edges with some of the issues and the way they approach it. So what I was going to cover in today's session were where harmonisation is at the moment, some of the key concepts and definitions that arise in relation to the legislation and how that may impact you and the way it leads to further obligations and overlapping duties, an obligation to consult with other businesses, which is a new obligation under the Act. A lot of organisations already, as part of best practice and contractor management, do that, but this extends it. How the laws in other jurisdictions can apply to you, even if you believe you're simply based in Victoria. How the Act defines officers and what special obligations they have, and some specific issues around plant safety. That's an ad for my LinkedIn group. I don't know if you're aware of that, but want some free information, there's a LinkedIn group, and you'll get a copy of these slides afterwards. It's got nearly 10,000 members now. It's free to join, and it's a discussion forum. Started off with a focus on the harmonised laws. It's now broadened out, but it's a very active group with nearly 10,000 members, including all the regulators. And that's just a quick note saying how important it is to join. Just to clarify where we're going today, though, in terms of the law, sometimes I find when I'm talking to people, they get confused about what occupational health and safety law is. And there's a number of areas that overlap. I mean, obviously there's a common law where people might sue for injury or damage and get additional compensation. There's workers' compensation, which is, of course, the statutory no-fault scheme for people injured at work. There's occupiers' liability legislation, which can apply quite independently of that, where someone occupies premises, whether it's a factory, car park, shopping centre, whatever it might be, they have responsibilities in terms of their obligations and duty of care to anyone on those premises. And then you get into the area, that's all compensation focused, then you get into the area where we're talking about punishment. You get the Crimes Act, where there were some amendments made in recent years to expand the stalking provisions to encompass bullying. And there's been a number of charges being proposed under that legislation at the moment for some members of the police force, I think. And then you get the occupational health and safety, work health safety legislation. And that's what we're talking about today. So sometimes when we're talking about the law, I find there's confusion about which aspect of the law is being covered. Now, harmonisation, as I said, was supposed to bring the world into beautiful focus, and it would have put occupational health and safety consultants and occupational health and safety lawyers like myself out of business in 5 years because no one would get injured anymore. Everything would be perfect. But as usual, things don't always go smoothly, and there's problems on the horizon. And whilst things look okay on the surface in terms of the legislation, the concepts have been introduced and people think they're understanding it. A lot of them are based on the principles we're familiar with, and we'll come to some of those in a moment. There are still a lot of matters of detail that are causing issues. Not everyone's in it for a start, so Western Australia and Victoria is still outside the framework. There were staggering starting dates. There's also changes to some of the transitional provisions. For example, Queensland has decided to again extend transitional provisions because it's thinking of tinkering with and changing some of the regulations. Codes of practice have not been uniformly adopted, and that again causes inconsistency for people. So even if you're working in the harmonised jurisdictions, you still can't simply assume that the code of practice picked up or endorsed by Safe Work Australia and the ministers is going to be enforced in your jurisdiction. You need to keep an eye on those things and check on them because it's still a bit patchwork. So those sorts of things are still part of the teething problems. In terms of where the laws are, you've got Commonwealth, Queensland, New South Wales, ACT, Northern Territory started on 1 January 2012, so it's well bedded in there. South Australia and Tasmania started 1 January this year. And each of them has varying transitional provisions, which means that the full force of the regulations are not enforced in all jurisdictions, and likewise with codes of practice. In terms of the other jurisdictions, Victoria has said it definitely won't proceed, and that was based on a risk assessment, a regulatory impact statement, which estimated the cost to Victoria at something like $3.2 billion. Now, the government never released the full copy of that regulatory impact statement. It released an executive summary. Half that executive summary was a disclaimer by the consultants who did it, explaining what the limitations were on the study and disavowing any responsibility for it. So there was a lot of criticism of that study, but politically, the bottom line is that Victoria won't go ahead with it. And I think for Victoria to join the harmonised process will require a change of government, and then it would have to obviously reassess. Western Australia has hung out for a long time. It's been very critical of the regulations. It's still considering its own regulatory impact assessment process, similar to what Victoria did, to determine what the cost impact on Western Australian business will be. And it is talking about introducing legislation, but coinciding that with changes to the mining legislation. It's recently been talked about that it may be bringing in a hybrid and not going the full way in terms of the changes. So what they're talking about in Western Australia is that there's 4 areas of the legislation they have said from day one they wouldn't accept. The first one is they don't like the maximum penalties. They believe that a maximum fine of $3 million for corporations is excessive, even though they have some of the largest companies in the world operating in WA with Rio Tinto and BHP. So $3 million is too high. They're talking about something like $1.5 million. The union right of entry they don't like. They say that should be regulated under industrial laws, not under health safety. The health safety rep's power to cease work where they believe there's an imminent risk of serious injury is something they won't accept. They believe that people already have the common law right and understand they have the right to stop work if something is seriously dangerous and an imminent risk. And they won't accept the reverse onus of proof in discrimination matters. Discrimination there being someone being discriminated against for health safety reasons. So if a health safety rep or someone raises a safety issue and finds out that suddenly they've been dropped from various shifts or they've got some disciplinary action against them, if they want to try and allege that that was based on their concerns about safety matters, they'll carry the onus of proof, which can be quite difficult, of course, if you're not party to the thinking and processes behind management decisions. So they're the changes that WA won't accept. There's another change recently. There was a prosecution recently, and I know this is pretty hard to read, but you'll get a copy of the slides, in South Australia under the old legislation, where a director who was charged had an insurance policy which, apart from the excess that he was payable by him, covered the fine he was due to pay. And the magistrate found out about this and was furious about it and said how it undermined the whole intent of the Act. And there's actually quite a lot of law around the issue about when you can and can't get insurance to cover you for criminal or regulatory offences. And it could be that this could be challenged. The regulator could challenge the insurance policy in court, but it hasn't done that. The bottom line was that this director had 90% of his fine paid for by the insurer. And because of that, the magistrate imposed a very high fine. He said that any expression of remorse, any submissions that the director made about personal finance, etc., and other grounds for mitigation were ousted by the fact he had this insurance policy. And he gave a high fine, I think, probably sending a message to insurers as well. Now, following that, the South Australian Attorney-General raised the issue about amending the Act to prohibit such policies, and has also indicated he's going to raise that, or has raised that, at the federal level through Safe Work Australia for consideration for amendment by all of the those participating in the WHS reforms. And there is a model for that based on the New Zealand legislation, so it wouldn't be unique. So that's something that may be a change in the pipeline. In terms of the new laws, what I want to do is take you through some of the concepts. For those of you who do work interstate, how many of you are familiar with the Work Health Safety Act and some of the changes it made? You're familiar with the terminology it uses and some of the changes? No? Okay, we'll talk about then. PCBU, a person in control of a business or undertaking, is the new terminology that replaces what was the employer. We'll talk about the scope of the duties owed by the various parties, definition of workers, which has also been expanded and replaces employees, consultation obligations, because they're significant in two respects, duties of officers, and special issues in relation to plant safety. Just to clarify the way the law works, there are a number of layers, if you like, of regulation. The principal law itself is the Act. So you've got the Occupational Health and Safety Act in Victoria, which you're all familiar with, Work Health Safety Act now in 7 jurisdictions, and Oc Safety Health Act in WA. So you have the Act, which is basically the core legislation. And as Jim was talking before about other examples, that sets out principles. It sets out your basis of your duty of care, certain definitions, defines high-risk activities, the obligation to set up health safety committees, the way you appoint health safety reps, and a whole range of other matters, including the obligations for plant safety and a number of other matters. So that's the core. Then in terms of developing that further, you go to the regulations, which, as Jim pointed out, runs now to in excess of 500 pages. And again, you'd be familiar with that massive amount of detail in there. But again, it's still, a lot of it is principle-based. Some of it will take you through step by step, for example, on key issues in relation to guarding of plant and machinery and the hierarchy of guarding controls. But in other respects, there's a lot of principles in there. And so from there, you need to go and look for other guidance. And that guidance can take a number of forms. You have codes of practice, which have to be gazetted in each jurisdiction by the government. So with Safe Work Australia, we've got a range of model codes of practice now under the Work Health Safety legislation. And you may have seen them on the Safe Work Australia website. You may have heard them being talked about and being part of consultation process. Even when Safe Work Australia approves them, it then goes to the Ministerial Council, which is all the workplace relations and health safety ministers. They need to approve it. But even if they've all signed off on that, they are still not legal codes of practice in any jurisdiction until each jurisdiction then picks it up and gazettes it in their state. So there's quite a range of codes of practice out there now which have been approved by Safe Work Australia, approved by the Ministerial Council, but may not yet all be in force in each jurisdiction, which causes a bit of potential for confusion and conflict. Then after the codes of practice, you have Australian standards, guidance documents and other matters. Now, some of the codes pick up Australian standards and reference them. So the Code of Practice in relation to plant contains over 80 international and Australian-based standards. as examples of the state of knowledge and the way you can approach matters. Others are just out there as part of the body of knowledge, and we'll talk about how that arises in terms of the Act, talking about what's reasonably practicable being based on state of knowledge. So you've got all those sources of information. The key one is the Act and regulations. They are the law, and a breach of those is an offence. Codes of practice and the other issues around body of knowledge, it's not an offence to do something contrary to them, but they may be used as evidence of what is known about a risk and the means of controlling it. So when we talk about the law, it's important to understand there are a number of layers. Now, I've got this one here as sort of basics because this isn't really a change, with the exception of definition of workers and extension for officers. But employer and PCBU still have a proactive duty of doing what's reasonably practical to control the risks and ensure the workplace is safe and not detrimental to health. Businesses, as before, have obligations not only in capacity as an employer, but also in relation to the extent to which they control or manage a workplace, they're in control of plant, they're involved in supply chains and so on. We'll come in more detail later on about officers and their obligation of due diligence, but also consistent with the old principles, workers have an obligation to take care for their own safety and for the safety of anyone else who may be harmed by their acts or omissions. So a lot of those principles are consistent with the current law in Victoria. I won't go through the detail of some of these slides. They're there more for you as the takeaway when you get the copy of slides at the end to refresh your memory. The Act is consistent with the Victorian Act, gives you the principles that apply, talks about management of risk, and in that sense, the Work Health Safety Act differs to the Victorian Act. Jim told you how in Victoria it was considered that you could skip that process. If something presented a risk and you believed there was a readily identified solution to it, you could jump straight from the identified hazard to the solution without going through a risk assessment process. When that was put forward by Victoria as a model for the Work Health Safety Act, and it came through in one of the early drafts, industry and unions screamed blue murder about it and said that it was inappropriate and that it would undo years of practice and training. The regulators tried to argue that it was only when there was a known solution, so that if there was something about, a simple piece of equipment and there was a recognised way of guarding it, you didn't have to go through all the process of a risk assessment. You could just go straight to the solution that might be in the Code of Practice or Australian Standard. But I don't know about you, but I know there are a lot of employees who say, if it's not in black and white, I don't have to do it. I've been involved in workshops where people have said, I've tried to show my boss the Australian Standard, and he says, show me where that's picked up in the law. And if I can't show that it's picked up in a Code of Practice or prescribed in the regulations, he says it's not relevant. So there was a concern that by not having the risk assessment process in there, that it would be considered something you didn't have to do. Now, lawyers also want to argue, and the regulators can argue, that the only way you can fulfil your obligation of doing what is so far as reasonably practicable is to do a risk assessment. I mean, Jim talked before about, the inspector comes in the door and wants to look at what you've done, what went wrong and how you might fix it. And the fact that you've said, I jumped straight from the hazard to the solution, the inspector will work through it by doing a risk assessment to say, well, no, you had the wrong solution. And in terms of what's reasonably practicable, the only way you can achieve that is to say, what is the hazard, what is the risk, what are the means of control, having regard to the hierarchy of controls. And you're working through them. If you don't meet that step, then you haven't got the right sort of control in place. So people could argue that implicitly the requirement to do risk assessments was still there, but I think the concern that was raised was quite legitimate, that in the absence of having it spelled out, a lot of people would say I don't need to do it. So you've got the question of management of risk. Is posed on a business for its workers, which is a broader concept, and I'll come to that in a moment. It applies to your workplace, fixtures, fittings. Designers, importantly, is defined in the Act as not only someone who designs plant from scratch, but designing or modifying any part of a plant. So if I've got an operational piece of plant and I change it, make some modification to it, or modify a part of it, then I'm considered a designer. And the obligations that attach to a designer apply to me in doing that. And that's important to understand because it can have a lot of implications. Likewise, you have the usual obligations we're familiar with in terms of importers, suppliers, manufacturers, etc. I'll skip through that one because it's some of the nuts and bolts of matters you'd be familiar with under existing legislation about health safety reps, consultation, inspectors' powers, etc. So they're just machinery provisions that you're familiar with. The regulations under the Work Health Safety Act, my picture's gone missing for some reason, are over 700 pages long. So there's a lot of detail in there. And if you're operating in Victoria, one thing you've got to work out is to what extent do those regulations differ from Victoria. Now, a lot of them will have consistent principles, but if you're used to doing something a certain way in Victoria, and you're also operating in the state, you need to be aware of where the gaps might be and where the differences might be. So the regulations also cover a lot of the basics you'd be familiar with, but as always, the devil's in the detail. Now, in terms of PCBUs, when that concept was first brought out, there was a lot of confusion about it. And people were saying, person in control of a business or undertaking, that must be the manager, the CEO, whatever. Now, it doesn't involve those people. A person in control of a business or undertaking, person is the legal identity of the business. So if it's a company, it's the corporation. If it's a partnership, it's the partnership entity. If I'm a sole trader, then I'm a PCBU as well. But it is not the CEO or one of the directors or one of the managers of a division. So the PCBU, in most cases, simply replaces the word employer. Now, the reason they've changed it is that there were some relationships of workers and bosses that didn't fall into the concept of employee and employer relationships. A couple of simple examples, and there's not many around, but the way taxi drivers operate and drive cars for the licence holder is not an employee relationship. But you would want to expect that there'll be a duty of care on the part of the owner of the licence and the vehicle to the driver. So this expanded definition brings in that relationship. Likewise, priests in the Catholic Church are not employees of the church. But again, there should be a duty of care for them and they should have certain responsibilities as well. So there are a number of relationships at the margin that are now governed by the Act that weren't before. But for 99.9% of businesses, no change at all. All you're doing is swapping the concept of a PCBU for that of an employer. And these obligations that used to flow around the concept of an employer remain in place for a PCBU, so there's no change there. And to that extent, you can say, well, look, it's a change in terminology, but the basic principles remain the same. In terms of, and Jim's mentioned this, the life cycle of obligations under the laws, they are also all there. So when you're talking about plant, substance or a structure, designer has the obligation, and that obligation is a full one in terms of identifying the hazards, assessing the risks, looking at what controls might be designed into the product, the plant or the substances being developed. The manufacturer has an independent obligation, so irrespective of what documentation the designer has provided, it's not a matter of simply just following that and saying, okay, I'm building what the designer's given me. The manufacturer independently has to assess the hazards, identify the risks and controls, because the manufacturer may be able to improve on those. The importer then has certain obligations in terms of provision of information to the party to whom they're supplying it. Likewise, the supplier has obligations in terms of provision of information to the recipient of the plant or structure. And those involved in installing, constructing or commissioning plant also have obligations, which I suspect would affect a lot of you. And then you finally get back to the employer or the PCBU, who obviously operates the plant and equipment, and others who are not in that circle itself but have their own obligations are your officers, workers and other people who may be in the workplace. And we'll look at their duties as well. So the whole life cycle is still there, just as it was under the previous legislation, but the penalties are much higher, and we'll look at those as well. Now, a lot of people say, with all that circle there's going to be a lot of overlapping duties. the manufacturer gets the risk assessment from the designer, the employer gets the risk assessment from the designer and manufacturer and the people who've installed it. They supply the manual that comes with the piece of plant. They may give them on-site instruction. People say, look, I don't need to risk assess it, it's already been done. I don't need to follow these steps, someone else has done it. The Act is very specific in dealing with that, and it's the same under Victorian law, although it's not spelled out in the same detail, that you can have more than one duty. Jim talked about people wearing more than one hat. You can be a designer, manufacturer, importer, supplier, and an employer in a workplace who uses the material. So you can have all those obligations, or they might be different people. But where obligations are shared, they can't be transferred to another person. So I can't say, they've done that job, I don't need to do it. I still need to carry it independently. And in terms of who's responsible, the law says each duty holder must comply, even if another duty holder has the same duty, and each person must discharge their own duty to the extent to which they have the capacity to influence and control the matter, or would have had that capacity but for any agreement. And that means you can't contract out of it. So if I've received plant, I've got all the risk assessments and everything else from the designer, supplier, I can't say it's all been done. I have to do my own risk assessment. And it may be that I end up confirming everything in the material. But it also may be that now that plant is in situ in my premises, that there are other factors that are relevant that weren't picked up in the general risk assessments provided to me. And it'll be no defence to me to rely upon the work done by someone else if I haven't fulfilled my own obligations. That's why you often have prosecutions involving multiple parties. Now, workers replaces the definition of employee, and workers include not only your traditional employee, but also contractors and subcontractors and their employees downline, labour hire, outworkers, apprentices, work experience students, volunteers. Now, that is not such a big change as it may sound, because even under the Victorian Act, I'm still responsible for other people who may be affected adversely by the way I run my business. If so, I've got workplace students or apprentices or labour hire, I'm still responsible for them. But I know at some forums when this law was being introduced and there was consultation going on, and I remember at one where someone stood up and said, I'm a health safety manager for a TAFE. We have 15,000 students. Are you saying that we're now responsible for their safety? And the answer is, you always were. You know, a lot of people are seeing changes in this legislation that didn't exist because what it's done in a lot of cases is clarify existing obligations. It has taken things that were buried in subsections, like in Victoria, an employer has a duty to a contractor and subcontractors, but it's tucked away in a subsection of the Act. And there's some language around it in terms of contracts of service, etc., and whether you can contract out of it. And people often don't see it, don't understand it, because not everyone sits there with a copy of the Act. A lot of employers have never seen the Act. They say, they're not my employees, they're contractors. But what's happened with this discussion is that people sometimes for the first time have said, well, you mean I've got an obligation for these people? And they're quite surprised when they hear they always have. So some of the changes that have upset people in this legislation have really been matters of clarifying existing obligations. So you've got worker now instead of employee, which casts a broader net and makes it very clear that the duty of care is owed to all these people. Where it does make changes, though, is in relation to consultation. Because in Victoria, you consult with your employees and in some cases contractors. In the jurisdictions now where you have the Work Health Safety Act, that obligation for consultation extends to all these parties. Now, for a lot of organisations that's not a big problem, but for some it is a major issue. So you've got the New South Wales Country Fire Authority with 20,000 volunteers. How do you consult with them in a manageable process? In Victoria, the CFA has about 15,000. If they had to consult with them by law, then they'd have those same sorts of issues. So for some organisation that has raised practical issues about how they go about it, and there's a code of practice which provides guidance. You don't have to sit down and talk to 15,000 people, but you set up a mechanism for doing it and consulting with people. The aspect that's new is what is being termed horizontal consultation. The legislation doesn't call it that, but that's what people generally refer it to. And that is that I've got an obligation as a business to consult with other businesses where we have shared duties. So if I'm going to supply plant to someone or install plant, commission plant on their premises, then we have shared obligations while I'm on their premises in terms of I'm going to be training some of their people how to use this plant. I'm going to want a clear perimeter around the plant machine, going to make sure it's properly guarded, can't be accessed inappropriately. And we need to talk about that by law. I mean, it would be common sense and probably common practice to do that in any event, but now it's a legal obligation. So anywhere where you have a shared duty with another business, whether it's in relation to design, manufacture, all those other areas in terms of safe working environment, safe plant, safe premises, etc., we've got to consult with people. And again, the Code of Practice provides examples and guidance on how far you go in that. Because again, there can be situations where it's quite complex and people say, well, how far do I have to go? And you could grind the business to a halt if you spend all your time consulting with other businesses and trying to sort things out. So that they are the aspects, not the definition of worker itself, but the aspects that can surround it that have led to some problems for business. Workers continue to have the duties they had under the old Act. They've always had the obligation to take reasonable care for their own health and safety and not to affect others. They now have new obligations to comply as far as they are reasonably able to do with any work instructions or directions, and cooperate with reasonable notified policies and procedures. Other people in the workplace, so if I'm, for example, in a shopping centre and the sign's up saying that this is a prohibited area, authorised personnel only, then I've got to comply with those instructions. And I also have these obligations. If I'm in someone's workplace and I start deviating from the path I've been told I'm allowed to follow, or doing things or interfering with equipment, then I can be in breach of the Act itself. So in the past, where some of these matters might have been disciplinary matters, they are now offences under the Act. And it gives an organisation greater power. It can actually say by law that other people in the workplace have certain obligations as opposed to simply by virtue of us allowing you on the premises. Now, when we talked about the obligation to consult with other businesses, this chart here is really just saying the duties that might overlap include safe work environments, systems, safe plant and substances, structures, welfare, obligation to provide information, instruction, training and supervision. I've got someone from labour hire comes in or someone else on my premises sharing a work site, monitoring workplace conditions. You say, well, okay, those obligations arise and they might be shared with designer, manufacturer, importer, contractors, a whole range of other people. So what you're looking for is where do the obligations that I have overlap with the obligations of other parties? And where they overlap, then the Act says I have an obligation to consult with them in relation to how we manage that shared obligation between us. Now, you're probably all aware, and I'll just skip through this part, it's really a topic in its own right, is that the statistics show that employees are safer than contractors. And there's a whole lot of reasons for that. Cultural, knowledge of the workplace, different cost pressures. When a lot of people contract out work because they're trying to save money, they'll take the lowest price, and you don't have control over the competence or the training of the contractors who may be provided unless you have a proper management process in place. So there's a whole range of factors there. And the backdrop there is an article from the Financial Review from many years ago talking about studies that demonstrate that, particularly in high-risk areas of work, that when you compare the accident rates between employees and contractors, contractors are invariably higher. There's been other studies done in WA in relation to mining fatalities and accidents which confirm those issues as well. So, looking at the corporate and personal responsibilities, you say that duty of care and legal obligations can't be transferred. You can have a way of, I can outsource them in terms of managing it. I can say the way I'm going to manage this obligation is to appoint someone to do it, have a contract to do it, but that doesn't relieve me of my legal liability. That is the way I'm trying to fulfil my obligation as opposed to getting me off the hook legally. And so I have the obligations to ensure that competent people are doing it, that I'm monitoring it properly. More than one party can be legally responsible. There are numerous prosecutions where contractors and subcontractors and principals are all being prosecuted in the one case, and they're all being found guilty and imposed with significant fines. Officers, managers, workers can delegate tasks, but that doesn't discharge your legal duty. You can't delegate and forget. You've got to monitor, supervise, make sure that the people you've chosen are competent and that you follow up on it. And ignorance is no excuse. Many people would like to say, I didn't know they were doing that. It's common to come into a workplace and find after an accident that management is saying the employee broke the rules. I remember one some years ago where it was a factory with very long lines of conveyors running the full length of the factory. And obviously to walk around them was a really long, time-consuming process. And all around the factory there were pictograms with indicating clearly that you can't walk across the conveyors. In this particular case, someone had been injured adjacent to a conveyor, got their leg caught between a trolley and the end of a conveyor. But in the course of going around, the inspectors were pointing to signs and asking people questions. And very quickly the employee said, oh yeah, but look, we all cross the conveyors, even management. And it's no good management in the head office saying, we were unaware of that. We had these rules in place, because it was clear that if they didn't know about it, they didn't have the right sort of monitoring and supervision in place. And the courts have developed a doctrine they call willful blindness or willful ignorance. And effectively they'll say that a manager or a company should have known what they would know if they'd been doing their job properly. And doing your job properly in those circumstances involves having in place proper supervision, instruction, monitoring, reporting mechanisms so that if someone is breaking the rules, you become aware of it. If someone breaks the rule for the first time and is injured, then you may find that you have a defence. If someone breaks the rule and their colleagues are saying, oh, we always do that, we always remove that guard, we always take that shortcut, then you're not going to have a leg to stand on, because the authorities will say you should have known that. Again, as I said, contractor management is a topic in its own right, but what that means in terms of when you're trying to discharge that obligation is you need to have a process in place. You may all be familiar with this, but and even when you're contractors and you're providing work to others, they should be saying to you, setting out their contract, what the risks involved in working for them are going to be. We've asked you to do this job. It might involve working at heights, working with dangerous plant, working in confined spaces. Here are the risks. How are you going to manage those? What's your expertise and competence? Where's your safe work method statements? Assessing those to ensure that you have a competent contractor, putting the details in the contract, managing the contractor prior to the contract commencing in terms of ensuring the competent people arrive, they've been inducted, they know the procedures, that they understand your on-site rules, etc., and what will happen if someone breaks them, monitoring that performance, and then review at the end. And they're the basic elements of what regulators are looking for if one of your contractors has an accident, to see if you have that in place. And if you've got all those boxes ticked and it's been done well, then they won't even charge you, but otherwise you could end up in court and be liable. Now, that session on contractor management could normally run 4 or 5 hours, so that's a very nutshell treatment. I want to move now on to codes of practice, so you understand what they are and what value you can take from them, because we'll come up to some of them in more detail in a moment. As I said before, the code of practice is a guidance document, but it has value in court as evidence of state of knowledge and means of controlling risks. The way they develop them is they'll pick priority areas. They'll say, look, working with plant is a high-risk activity. Working at heights is a high-risk activity. Confined spaces. We need to provide more guidance on these because the Act and regulations are all still fairly high general principles. So what they'll do is they'll pick an area, they'll then develop a draft. It goes out for public comment. Under the Work Health Safety Act, what happens then is Safe Work Australia digest all the comments, make amendments, they may put it out for further consultation, comes back, they finally vote on it at Safe Work Australia. It then goes to the Ministerial Council, who vote on it, and again, by majority, if it's accepted, that becomes an approved model. But then each jurisdiction has to independently pick that up before it becomes an authorised code of practice in that state. And that's where some of the problems are occurring. This is a list of the existing model codes that have been finalised under the Work Health Safety Act. A lot of them won't be relevant to you, but obviously a key one will be managing risks of plant in the workplace. and one that has disappeared, that one there, is still not yet finalised, but safe design, manufacture, import and supply of plant. And they also include as annexures a very long list of Australian and international standards, which they call up as being relevant. They're not called up as matters of law, but they're there as part of the body of knowledge, what you're expected to know and understand if you're dealing with those sorts of plant. And part of the eternal debate that we get with some people is that, you know, you have over 80 standards listed in the back of the Code of Practice on Plant. To buy them would cost you $4,000 or $5,000. Then you've got to work out, well, do you actually need them? I mean, some of them will be obvious you don't need, but others you might only need a couple of pages out of them. And so the question about access to and availability of what may be a legal requirement. But there's a number of codes there, including how to manage work health and safety risks, which goes into a lot more detail. The regulations itself under the Work Health Safety Act, unlike Victoria, actually specify the hierarchy of controls, and the Code of Practice takes you further into what they expect by way of risk assessments. So whatever I might do in Victoria, if I'm working interstate, the authorities there will expect something very different in terms of risk assessment process to going straight from hazard to solution. So one of the things that, again, complicates matters is there's something missing from that picture. Here's all the regulators who've approved those, and WorkSafe Victoria is missing, because when we had the change of government a few years back, they stopped participating in the process totally. So even though Western Australia has still not picked up the legislation, it has been fully involved in the process for developing and consulting on the codes of practice and has signed off on and been involved in those that have been approved to date. Victoria hasn't. Now that creates a bit of a dilemma for you, because whilst you'd hope there's no conflicts between various codes, there are going to be differences, of course, in terms of their scope and coverage and language and the way they approach matters. So if you're working across jurisdictions, you've got to be conscious of the fact that these codes of practice may expect you to do certain things or be aware of certain things that you may not be accustomed to working with if you simply relied on the Victorian code in the past. Now, there's obviously going to be a significant degree of overlap, but what you need to watch for is where some of the changes may be. There's others that are in the pipeline. It's the same one again. Safe design is there. Traffic management, cash, amusement devices, a range of others that are probably not relevant to most of your work. There was one being developed, the Code of Practice on bullying. That's now been decided it's going to be downgraded to a guideline because they couldn't get people to agree on it as a Code of Practice. There's others for stevedoring, fatigue, and others that will eventually come through. But being based in Victoria, even if you don't operate outside the state, you've got to remember that when the legislation in Victoria says that reasonably practicable involves understanding the hazard, the risk, and the means of control and state of knowledge of that all these codes of practice now, even though they're not picked up as codes in Victoria, are part of the body of knowledge out there about the level of hazard, risk, and means of control. So you can't ignore them, even though they're not gazetted in Victoria. So if you see any of those that you believe are relevant to your activities, you need to be aware of them and incorporate them in your practices. When you look at plant, the problem gets a bit more complicated. I mentioned to you before that the codes haven't all been picked up uniformly. And so this is a chart, or part of a chart I've done, where it's looking to what extent the codes approved by Safe Work Australia and the Ministerial Council have been gazetted in each state. So you can see that consultation one is fine, except Victoria and WA, because they haven't picked up any WHS codes yet, even though WA has actually participated in them. Electrical risks, you start to see problems because Queensland, New South Wales and Northern Territory have not picked up the Work Health Safety Model Code, even though they're operating under the model legislation. First aid likewise. When you get to plant, again you find Queensland, New South Wales and Northern Territory have not picked up the model code on plant. So you've got the Victorian Code of Practice on plant, you've got the model one, you still haven't got the set because there's a number of jurisdictions where that's not available. Now, if you break down the detail, you look at, these are the harmonised jurisdictions. 4 of them have the work health and safety, they all have the regulations. 4 of them have the harmonised code of practice. Queensland has the Plant Code 2005. It's still talking about sometime in the future bringing in the model code. New South Wales has no specific code but has elements addressed in various documents. Northern Territory likewise no specific code, but it's broken up in a number of other documents. Victoria has the 1995 code as amended, and Western Australia has a 2009 code. So if you're operating nationally, you've got 6 different codes of practice to look at, even though we're operating supposedly in a harmonised jurisdiction for at least 7 out of the 9 jurisdictions. And that can be a real catch, because some of the codes, like the Queensland Code of Practice, has a lot more detail on installation and commissioning than any other codes. A lot more detail, which you could run foul of. Now, not trying to be too dramatic here, but there's some graphic images that follow. So if people want to avert their eyes, it's fine, but because some people I know find these things disturbing. When you're talking about hydraulic plant and equipment, it's not simply a matter of people getting crushed in power presses or mincers or whatever. There are specific injuries you can get from hydraulic pressure, and they're not always appreciated. But when there's a leak or a burst, something under high pressure, the force with which the oil or the fluid, whatever it might be, can be ejected can cause horrific injuries. And sometimes they're not even realised immediately. In fact, there are some cases where people have received an injury. One case, someone put their hand in trying to check where a leak was, felt something sharp, came out, they had what looked like almost a prick on their finger and a bit of blood around it. Didn't realise what had happened was they just received a significant injection of oil into their system, and that can have horrific consequences without them realising it until some hours later. This is an example of a projectile blown through somebody after a failure of hydraulic equipment, and I've got the references for this that I can give if anyone needs it. But then you get to this one here. Now this is from One Steel. They put out a hazard alert. You can see here, tiny hole in this line which led to high pressure fluid being ejected. And what they say was the fitter found the small leak, requested the machine to be shut down so the hose could be replaced. When the machine was shut down, the fitter placed his double-gloved index finger over the wear spot on the hose so as not to lose the location of the leak. He was not aware that the machine system remained pressurised and actually increased pressure, a back pressure hazard, for approximately 2 seconds after the shutdown. Hydraulic fluid burst through the wear spot on the hose and injected through the double gloves into the fitter's index finger. So you got a tiny hole like that, and that was the consequence after he had his surgery to try and salvage his finger. They had to follow where the injected fluid had gone through his system and address it. So something as simple as that, just checking to see where a leak was or not lose the spot, leads to that sort of horrific injury. And in the slide that follows, there's some more examples of serious injection injuries. They can lead to amputation of limbs or death if not treated properly, because the fluid runs through your system and kills all the tissue around it. So there are hazards associated with hydraulics that go way beyond the ordinary issues that people may be familiar with in terms of plant safety, and that obviously your organisations or your customers need to be aware of. Unless people understand that, they won't understand the significance of not putting hands in certain places or near things or checking. So it's very important that those broader risks are understood. In terms of reasonably practical, I won't labour this because you'd be familiar with the Victorian legislation. The definition in the Work Health Safety Act is based on the Victorian legislation, and the Western Australian had a similar definition. So you've got likelihood of the hazard or risk occurring, degree of harm, state of knowledge, availability of controls. And what they have amended in terms of cost, they've tried to clarify the cost factor by saying cost is only relevant if it's grossly disproportionate to the risk. Because too many people are getting confused over cost, saying, oh look, I can't afford it. It's next year's budget. Now cost has nothing to do with that. I mean, in a small business, if someone can't afford appropriate controls on particular hazards, then the answer is they shouldn't be in that business. And they should contract out that part of the work or whatever it might be to someone who can afford the equipment. But the courts have gone out of their way to try and make it clear to people that cost is not a defence unless you're talking about a relatively low risk and a grossly disproportionate cost. If you're talking about a potential fatality, then there's no way you'll be able to say the cost is just disproportionate. Now, I'll skip through this, I think, because of I think you'll all be familiar with the issue, but I'm happy to come back to it if there's anything you want to question about. Likewise, the hierarchy of controls. None of that's changed under the new law. What we find is that in terms of risk assessments, people often understand the consequence, the exposure, but where they go wrong is on the probability. And people make all sorts of mistakes there, and of course it alters their whole risk assessment equation, and they end up then opting for lower order controls. And the easiest way for WorkSafe in any jurisdiction to prove something wasn't, so that something was practical that wasn't done, is usually, as Jim said, you come in and ask the operator what should have been done, what's the procedure. There's been a departure from that. Well, did that cause the accident? Well, there's your answer already. But how many organisations do we know of where there's been an accident and within days, sometimes hours, they've internally fabricated some part or guard or made some change to a procedure or to their equipment to minimise the prospect of it occurring again? And once they do that, they've demonstrated the prosecution case. There'll only be rare instances where they can say, look, this was completely unforeseeable, and it's only with the benefit of hindsight that we can now see this control is needed. But in most cases, you've got to remember that WorkSafe walk in, they have the benefit of 20/20 hindsight. You can follow back what's happened. You can easily pick a point in the chain, either of the equipment and guarding or the processes that we use, where if you change it, you minimise the risk of this incident ever occurring again. So, and there are numerous cases where people miscalculate on risk assessments using the wrong factors because they don't understand the whole process of risk assessment. And we'll look at one of those cases in a moment. And part of the problem with this, as I say, people know those issues. You also get, if you want to go into detail, I think cognitive biases, which people have shown over time. As human beings, we can't always do all sorts of calculations in our mind, so the mind takes shortcuts. We make assumptions, and people are not always aware of the assumptions they're making. And they're not just idiosyncrasies for individuals. What they are is they're replicable in tests, psychology tests and others, where they'll get groups of people, they'll test them, and they find that people regularly make assumptions about risk where they underestimate matters, or confirmation bias. We've had this equipment for 30 years, nothing's gone wrong, therefore nothing will go wrong in the future. They make assumptions consciously or subconsciously which have nothing to do with reality and the real risks and the probability of something occurring. And so that part of the problem is that whilst it's important to have your workers involved in risk assessment processes, you can't let those sorts of factors overrule the reality of what the issues are. Some of you may have heard some years ago about a fatality at Amcor out at Fairfield. Anyone hear that one? I won't go into the detail of it other than just some key issues. It was a very large process. I mean, you're probably familiar with the Amcor factory out there, the length of it. Now, this paper mill ran the length of the premises. It was a very large operation. In terms of size, you got rollers, and Jim had actually been there, but so he can tell me if I'm wrong, but rollers, the size of a man. In terms of the paper process, you've got the paper running through these rolls and starting as pulp at one end until it's paper through the other end. And along the way, there's a cleaning process required. Sometimes there's tears in the paper, sometimes there's fibre build up, there's dirt on it, and it's obviously a very simplified diagram, but what was required sometimes was blowing an air hose into the paper to clear off fibre or dirt, and the control that was in place was a painted line on the floor that the operator wasn't to step past to avoid getting risk of entanglement or injury. They had done a series of risk assessments over the years. In fact, in the previous 5 years, there have been 2 risk assessments where the risk of someone being pulled into this had been noted, but those involved in the risk assessment, which tragically included the father of the man who was killed, considered that that risk was remote and unlikely because they've been doing this for 30 years. I think 30 or 35 years the equipment had been in place. On this day, of course, though, something went wrong, and for whatever reason the operator got too close and he got pulled into the rolls, entangled and killed. The only prior injuries or near misses had been 2 incidents, one where someone got too close to a roller and had a friction burn, and one where someone felt either their clothing being tugged but pulled away. So the company's position was 35 years with this process without a serious incident. Now, there was no code of practice on the equipment, there was no Australian standard on its guarding, but it took WorkSafe through one of the experts they retained a matter of probably less than an hour to identify that in the UK there was a standard for the guarding of this type of paper mill. And when Amcor costed it, it was around $800,000 to put the guarding in. And of course they shut down and they put the guarding in. When they went to court, they pleaded guilty because they realised that there was no hiding. I mean, Jim talked about the Labour and Industry Act and regulations that used to define dangerous parts. In-running nip points have been known to be dangerous forever and need guarding, and especially something this size with people working close to it. So they pleaded guilty, but as part of their mitigation of penalty, they said 35 years without a problem. We've also significant cost, $800,000 to install. We had to shut the plant down. We lost significant dollars in shutting the plant down. And also there'll be ongoing maintenance costs with this because with the large framework now of guarding around the equipment, there'll be an increased fibre build-up of paper. That increases the dust and contamination risk and fire risk. We need to shut down on a far more regular basis for cleaning. And that will add about $1 million a year to our production costs. So that was all part of the plea, and the court basically said, tough, forget it, sort of no excuse. I mean, they got to fine the county court, WorkSafe appealed to the Supreme Court or the Court of Appeal, where the judges said the fine wasn't high enough and tripled it. At the time, it was under the old penalties, and the maximum was, I think, a maximum of $500,000 per offence. They were fined $360,000 for the offence, which is about 75% of the maximum. And courts tend to work in those degrees, saying, well, Parliament has decided how severe this is by the maximum it sets, and we will then grade a penalty based on where we see this sitting on that scale. So, but the important thing I think was if you imagine, if you were the health safety manager there, and you'd identified this issue, disagree with the risk assessment, you went to your production manager and said, look, I know we've run this for 35 years without any serious incidents, but it could kill someone. I want to spend $800,000 on guarding. We need to shut down the plant for a month to do it, and it'll add $1 million to our production costs. Who thinks, and that's per annum, who thinks they would ever get that through? So you can see the dilemma for, the health safety manager. And I tell people now, if they're in that position, to carry a copy of this case around in their back pocket. But, the court had no hesitation in saying this should have been done. There's been other cases like it where when the risk is high, the court says the cost is irrelevant and should have been done. So when you're talking about what's reasonably practicable, people get confused by long periods without an incident, lack of available data. There's only about 3 of these sorts of operations in Australia. So in terms of looking at comparative data about accidents, they didn't have the figures. There was no real indication. But it depends too whether you're comparing. Are you comparing the injury rate on paper mills, or are you comparing the injury rate on in-running nip points? So there's different ways of looking at it in your risk assessment process. And then you get back to the question about who's doing the risk assessment, who's making the decisions, and how competent are they, how well do they understand the process.
Excuse me, Graham,
yeah.
can I make a comment on that
Yes.
machine?
Yep.
30 years ago, my own cousin got caught in the machine and was thrown and got severe cuts, and he had a fractured skull. He was taken to a local doctor. This was on night.
Yes.
Taken to a local doctor who patched him up, and it was all settled quietly. And they took him back to the plant and set him in the corner and said, "Don't go to the machine for the rest of the night, or this injury will ruin our production bonuses." So it never happened.
Yeah, and that's not uncommon.
My very
Yeah.
first cousin.
Yeah, look, I've heard of things like that before. I know a health safety manager who went to with a 24/7 operation. This person went there one night just to have a look around, came in and found a guy just sitting in a corner somewhere doing something fairly basic and irrelevant. She said, "Why are you on now?" He said, "I've got an injury, but I've been told to come in for 3 hours a day to do this so that I'm not on the stats."
Yep.
And so, yeah, look, you get those sorts of problems. So it's important we keep that sort of case in mind when you're talking about what's reasonably practical and the cost factor. Now, that's where this becomes relevant, because when they were doing the new legislation, they said, well, for someone to get leverage on that and get decisions made, it's the officers, it's the senior people in an organisation who decide what gets spent and when. And unless you're going to hold them accountable, things aren't going to happen. Now, under the Victorian Act, directors are liable if they consent or connive or are negligent in the way they respond to certain health safety issues. And that's a very high standard to try and demonstrate. What they've done under the new Act is they've said, okay, let's put a positive obligation on officers, a duty they have irrespective of whether there's an injury or a breach, something that an inspector can walk in and say, show me what you're doing about understanding your obligations and what you've got in place. And if they haven't got it there, they could be prosecuted or given a notice to comply. So what they've done under the new Act is, first of all, they've defined officers, and they've picked up the definition in the Corporations Act. It's a person who is a director or secretary of the corporation, so straight off the senior directors and the secretary of the company are caught. Then anyone else who makes or participates in making decisions that affect the whole or a substantial part of the business. Now, it's designed not to catch middle managers, it's designed to catch people at the highest level. So you might have your chief financial officer, potentially the human resources manager, some of those other very senior people. Or they have the capacity to affect significantly the corporation's financial standing. And here's another catch too, they needn't even be a member of staff or on the board. So if, for example, and this is with due respect to her, I'm not blaming her for anything, but Gina Reinhardt, she owns a company, she's the major shareholder, but she's not on the board, not on the staff. She phones up and tells the board she wants something done, you would normally expect them to comply with her wishes. So even though she's not anywhere in the paperwork on the company other than as a shareholder, she's someone in accordance with whose instructions or wishes they're accustomed to acting. And so she could be roped in as an officer if something went wrong in one of her businesses. And there's been cases where that's been considered to include the legal advisor. So in different contexts, because officer is a concept that's used in corporations law, trade practice and other legislation, the legal advisor, internal legal officer in the James Hardie matter was considered an officer of the company and responsible as an officer for some of the advice he gave to the board around the issues of their setting up of the asbestos compensation fund. There's also been guidance issued by Safe Work Australia based on the case law about what participating in making decisions means. And so if I simply go along to a board meeting and they ask my view on something, I give them my opinion and they ultimately decide to act on that, that would not be considered participation. But if I'm closely involved in their decision making, I'm getting data for them, I'm helping them formulate their views, giving them guidance, I could be caught by that. So there's no black and whites in it. It is deliberately in one sense vague because it's intended to catch people who wield power even though they may not have a title in the organisation. And so you'll find obviously that gives rise to concern, and what a lot of organisations are doing now and have done previously under the Corporations Act and other legislation is they've mapped out who are the officers in our corporation. And they carry a whole range of obligations, not only under work health safety law, but under other legislation as well. So it's important that they be identified. Now, what can happen then is you get visited by the authorities one day, and they're always very friendly and helpful. What you'll find is sometimes there's going to be some questions. I better cover this up in case the camera... And I want documents and things. Now, recently I acted for a company based in Victoria which supplied some plant to a business in Queensland. Now, the Victorian business is based here, operates here, but supplies interstate. So they're sitting there thinking, okay, we're subject to Victorian law. But once they go to Queensland and supply the plant there and install and commission it, they're actually under the Queensland Work Health Safety Act and all the obligations and penalties that brings with it. And they installed this piece of equipment, which was clearly dangerous. In all the manuals that accompanied it and all the instructions that accompanied it, it gave repeated warnings about the hazards associated with the equipment. And it gave very clear recommendations on the guarding that was appropriate in terms of safety mats and light curtains. Now, when they quoted on the job, they actually included in the quote various guarding options. The company that purchased it said, we don't want any of that. We'll make our own decisions. Now, we're not talking about a cheap item of plant. It was about $360,000. The guarding, I think, would have added less than $5,000 to that cost. So they attended, they installed the plant and equipment, they commissioned it, they trained some of the operators on it, and whilst that was occurring, because this equipment sometimes took different configurations and floor space, the owner of the premises put a plastic chain around it, but assured the installer that he was going to get appropriate guarding. Now, of course, 6 months later, the plastic chain was still there, and one weekend, an employee working on it got himself caught in the machine, his arm trapped, and he couldn't get out. And he was calling out for nearly 2 hours before someone in an adjoining factory heard him, came in, and he was able to then instruct them on how to release him from the machine. I haven't heard the full details of his injuries, but he suffered very serious injuries to his arm. He was fortunate not to have bled to death, and he's still suffering psychological trauma after being trapped in it for 2 hours. So, WorkSafe Queensland looking at obviously prosecuting the organisation that installed the plant, but they also contacted the Victorian company and said, we'd like to interview you. And they flew down to Victoria to conduct an interview about the whole process. And this is where some of those issues about plant codes of practice come into play, because the Queensland Code of Practice has quite a lot of detail on installation and commissioning of plant that you won't find in any of the other codes of practice on plant. And so they took them through a series of questions on that. But the first question in the interview to the officer or to the manager who'd been authorised to represent the company in the interview process was, after going through the formalities of do you employ these people, etc., what has the company done having regard to its obligation under the Queensland Work Health Safety Act to ensure that its officers are aware of their obligations under Queensland law and have in place the appropriate places to exercise due diligence? Now, that's the first question they asked before they got into all the detail of the incident. So if you're operating interstate and there's an accident, and I believe it'll be a standard template question in any of the work health safety jurisdictions, because they're looking to broaden the net to look at people who are responsible at the management levels. They'll say, what has your organisation got in place, what have your officers got in place to ensure they understand the law? And I'll come to what due diligence requires in a moment. So, that can be very sobering. You think, you've been doing something for years the Victorian way, and suddenly you're in another world. This again is taken from a session that can normally take a half-a-day presentation, but it's just to remind you what happens during an incident.
This company which supply equipment plant to Queensland.
Yes.
And initially offered safety equipment.
Yes.
Which end user decided not to take.
Yes.
Was this company prosecuted for it?
We're still waiting to hear. They've been through the interview process, but what Queensland is saying is you should not have installed or commissioned the plant in an unsafe manner. And also they've interviewed the employee who did the commissioning work and said, why did you train these people on the machine when it wasn't properly guarded? So
The company should have refused if it declined.
that's what they're saying now. The organisation is saying, apart from anything else, it used the standard industry contract, the AMTIL contract, and it's saying, well, look, we're on their premises, we've offered them, they've said no, we've got certain contractual obligations, we use the standard industry contract, so we're waiting to see what WorkSafe Queensland says about it all. But their view, and the reason they interviewed the client, was that you should not have installed it without guarding, you should not have left it, you should have put a lock on it and waited until the client had guarded it appropriately. Now, there'll be debate amongst consultants whether that's fair and reasonable or not, but that's the view that the regulator took. And if you look at their code of practice, which differs from the others, it sets out detail to that effect. So, we've got to wait and see whether they actually prosecute on it yet. When an incident occurs, though, you have a whole lot of things happening at once. You've got the rescue of the people, securing the scene, care of other employees who may be traumatised and need counselling. You have third-party notifications, the regulator, you might get a consultant in. If there's contractors, they might have lawyers and investigators involved. You might have the media, you've got injured party and family. Trade union might come in and want to know what's going on and want to slap bans on the place. All those can be potential legal proceedings, which we'll look at in a moment. You've got the internal response in terms of internal reporting of the incident. Your own investigation, is that going to be under legal professional privilege to protect the documentation or not? Do you investigate with internal expertise or get someone like Jim or someone else to do it? Have officers got sufficient processes in place for due diligence? Do they have conflicts of interest with the company or between each other in terms of someone might have said we should be doing this, someone else said no we shouldn't, we can't afford it. So you get different interests there. What are you doing after the accident? What implications does that have for the case in terms of proving practicability? You can have a coronial inquest, prosecution, challenging notices. There could be actions for damages, or under workers' compensation, the insurer could be suing for recovery. So incidents can be complex, and people need to be aware of all these issues and have a process in place to manage them. Because otherwise, if you try and start thinking of all these things when it happens, you're going to be sort of behind the eight ball from the start. This is just a reference to that case I told you about, where the first question they asked was, can your officers... They said, who are all the directors on the company? And what have they got in place for due diligence? So what is due diligence? It's not new. Initially, when the draft bill was introduced, it said officers have an obligation of due diligence, and it didn't define it. And business said you can't just do that, and the regulator said it's already defined in case law, because it's already part of the Trade Practices Act, the Corporations Law, and a number of other pieces of legislation. Certain environmental laws contain it. And business said, look, we need something in the legislation as guidance to provide a framework so that businesses understand where to look, because we haven't all got lawyers on tap to tell us what it means. So they defined it, and here I've broken it up into a number of elements, personal and business. Those two headings don't appear in the Act, but what it says is an officer must exercise due diligence to ensure the business complies, and that includes taking reasonable steps to do the following. The first two I've classified as personal, is that the director has to, or officer has to understand the nature of the business and the risks and hazards it's facing. So I might get put onto a board of a company because I'm an expert in Asia, import exports, and thinking, we want to tackle the Asian market. And I might think, that's why I'm there. I don't need to worry about the financial side or the safety side. There are other people doing that. The law now says that's wrong. I have to understand the scope of our operations and what hazards and risks that presents. I have to have a broad understanding under item 2 of the legislative framework and what obligations that imposes on me and the company. So I don't need to know the law backwards, but I have to understand things like reasonably practicable and concept of worker and PCBU and what duties are held and what we need to do to discharge them. Now, with that knowledge, I then have to look at the business and say, does the business have in place appropriate resources and processes to identify the hazards, assess and control the risks? So if we haven't got a proper risk assessment process, or we've got a list of matters that we're planning to fix in next year's budget, then I'm going to fail on that step. Next one is, do we have appropriate reporting and response mechanisms in place to ensure that matters are addressed in a timely manner? If someone identifies a hazard or raises a problem, how is that dealt with? If there's an incident, who is notified? How quickly is it responded to and addressed? If there's an audit and there's corrective actions identified, how quickly are they followed up on and addressed? So what sort of processes are in place for that? Process for legal compliance with the duties. Have I got a means of keeping up to date with what the law is doing, with new codes of practice as they're being developed? And am I confident that the business understands what codes or what developments may be relevant to it, and that it is then appropriately reflecting that in its WorkSafe procedures? And then, have I got a process for verifying that those steps are being done? Now that might be an internal process where the health safety manager on a regular basis reports to the board, and it might be that every 2 or 3 years I get an external audit to make sure the work health safety manager is not pulling the wool over my eyes, or that they haven't got blind spots and ignorance on their own part. So that is what due diligence constitutes. And it's a positive duty, which means an inspector in a work health safety state can come in and say, you're a director of this company, show me what you have in place to meet your obligations of due diligence. If that director or officer in any category can't produce something, the inspector could potentially prosecute them. In these early days, I think that won't happen. But what they could do is, for example, give them a notice and say, I'm going to come back in a week's time or 2 weeks' time. You've got a improvement notice here. I want to see all these things in place. Now, of course, if something goes wrong in the business and you're lacking those processes, then the officer can be charged personally as well, because they'll want to say to the court, part of the problem, part of the issue that led to this accident was that these processes weren't in place and the officer has failed to ensure that the business is complying with its obligations. So the whole idea of this legislation was to move work health safety very much into the boardroom, and for the key decision makers to realise that they can't simply defer things in the budget. That in the Amcor example, if someone comes along and says this is a problem, that an officer who rejects that does so at their own risk. Now, in reality, we know that businesses can't always do everything at once, but what it means is an officer confronted with those matters has to realise that in deciding to defer something, they are taking a conscious risk personally, not just for the business. And one of the things I say to people about whether the systems might be right, you think how many organisations have in place really tight cash controls, levels of authority for signing off cheques or requisitions of certain amount, petty cash vouchers. If you're in court and someone said to you, how does what you've got in place for health safety compare with your financial controls or your quality management processes or any other risk management processes in the business? And if you've got tighter controls on your petty cash than you have on safety, then I think you're going to be in trouble. So, that's not a legal matter, that's just a benchmark to say, well, if you're talking to management and they're saying, oh, we're okay, say, well, look, compare what we're doing with something that relates to the life of people compared to what we're doing with finances. So it's just one way of looking at it. In terms of law applying in other jurisdictions, just to emphasise, the Queensland example is one case, supplying plant. Here's another one where a few years back, the Australian Government Department of Immigration ordered a series of boats. They were being used to ferry people around some of the islands off the north coast of Queensland, Torres Strait Islands. And they went out to tender with specifications and they got a great deal. They picked the cheapest boats. And the manufacturer, there's been a documentary on this on Four Corners since, as well as some court cases, the person who designed and manufactured it did so in record time and supplied the boats and also provided certifications that they met Australian standards. 6 weeks after receiving them, one of the boats sank at sea, killing 5 people. Now, even before that, the boats had had some problems with leakage and taking on water. And when they never recovered that boat, they never found the bodies, but when they took the other boats apart to look at them, they found they lacked any buoyancy. Now, you can have foam in a boat for buoyancy, or you can have airtight compartments. He'd opted for the cheaper airtight compartments, but they weren't airtight because the welding was shoddy. There are a whole lot of other factors that were deficient. From the Department of Immigration's point of view, they didn't supply charts, GPS or radio to the boat. Went for the cheapest quote, didn't comply with Australian standards. The compliance certificate was fraudulent, shoddy welding and poor and missing navigation equipment. And the department was prosecuted by Comcare in the federal court, but they also prosecuted the supplier of the boat. Now, in ordinary circumstances, he would say, hang on, I'm based in New South Wales, I'm not under the Commonwealth Act. But because he was dealing with the Commonwealth in this matter, supplying to them, he has legal obligations under that, just like the company I was talking about supplying into Queensland gets caught by the Queensland Act. So you need to realise that if you are dealing with a party in another jurisdiction, then you become subject to those laws. In terms of design of plant, there's been lots of cases around things like mulches, not complying with Australian standards because of the ability to reach in. I won't focus on those just for time reasons, but this case I think is an interesting one. There was a company needed and this is not a photo of the actual door, but something similar, a large steel door, and it was going to weigh about a tonne, and it was operated by an electric motor, and they did their own specifications, got quotes on it, and provided the specifications to a manufacturer, who then built the door to their specs and installed it. Now, it was driven by an electric motor, but on this particular occasion, the motor was having problems, and so an employee at night was locking up and was trying to close the door manually. A customer was there, decided to help him, so they were rolling the door closed and ran over the edge, fell, and crushed and killed the customer. And WorkCover New South Wales prosecuted not only the employer of the premises, but also the manufacturer of the door. And part of the manufacturer's defence was, but we just designed it and built it to specification. And the court said, you're involved in the design and manufacturing process. You had an independent obligation to do a risk assessment on it and to put in place appropriate controls. It's foreseeable that a door of this size driven by a motor must sometimes be operated manually. It's foreseeable in those circumstances there be certain risks, and you're guilty. So it's not a defence as a manufacturer or designer to say, I'm simply following the specs. You may recall when we talked about the obligations before, overlapping obligations, they're independent and discrete. So if the client comes to you and says, don't worry about that, all I want you to focus on is this, you've got to say, well, no, actually I have a legal obligation to address these other issues, irrespective of what your contract says. And that may alter your quote on the job, but it's important to realise you can't simply hide behind the fact that you weren't asked to do something if the law says you have an obligation to identify those risks and address them. This is another example of a matter where someone was trapped in a conveyor line. They had this trolley car that ran up and down on some tram lines, if you like, and was computerised and automatically picked up goods that came along the conveyors and over on the rollers. And it had a PLC sensor in it, which would detect anything in the way, and it would sound alarms and flashing lights. If someone got within the warning zone, it would slow down, increase the frequency of the beeping. They got to the protective zone, it would stop. They had all sorts of testing to make sure that it was fine, but they also found that because it was an old building, it used to snake a bit on the tram lines as it went down the premises, and they found that the scanner was actually picking up the end of conveyors and kept tripping and stopping. So the technician worked on the scanner and narrowed the field slightly so that it wouldn't trip on the end of conveyor lines. Now, normally no one will be working in that area, but on this occasion, an operator thought he put the wrong label on some boxes, so he ran to the end of the conveyor line to check the box and change the label, and he had his foot sticking out, the safety boot on, and the scanner missed it. His foot got caught in the end because they'd reduced the field scanning zone, and his boot was just underneath it, and it caught his foot, and because of the steel cap in the boot, twisted his foot 360, kept turning, and effectively wrenched his leg off, screwed it off. When WorkSafe looked at it, initially no one could work out how it happened because they did all these tests, and every time they tested it, the machine stopped. Then finally, they got a boot put in a similar position and found that there was a gap in the field. Now, the company was prosecuted, convicted and fined. There were all sorts of other arguments and issues in the case, but that would constitute a design modification. So quite apart from the employer's duties, modifying a piece of the plant or equipment, altering its specifications is design work. So you need to be aware of that. And that's whether it's in Victoria or in interstate. In terms of duties of care, the highest duty of care is on the PCBU or the employer, and that's a duty of what's reasonably practicable. The second highest duty of care is on officers who have or the decision level making the organisation, due diligence. So it's not quite as high as the organisation itself, but it's still a very high burden. Workers and other people on the premises have a duty of reasonable care. So that's the distinction between the three levels of duty. In terms of financial sanctions, under the new legislation, you can see here, Victoria, roughly $1 million is indexed each year. It's about 1.1 or 2 at the moment. New South Wales, these are the old penalties. Under the model legislation, it's now 3 million. For individuals, the fines are now up to $600,000 compared with the 200,000, 250,000 under some of the old legislation. And in terms of imprisonment, in the ACT they got a remission because they used to have 7 years, now it's down to 5 years. But there are other jurisdictions where Northern Territory and Commonwealth had no term of imprisonment as a sanction. Others had lesser terms. Under the model, it's 5 years. And I believe it's only a matter of time before someone will go to jail. There have been suspended sentences issued in Victoria, even under our own Act. Overseas, people going to jail is not frequent, but certainly not uncommon. There are cases of people going to prison in Italy, America, UK, and a number of other jurisdictions. So I think it's not a matter of if, but it definitely will happen. It's just a matter of the right circumstances and a judge who's so disposed to exercise that power. The Act breaks up fines into different categories based on severity. So highest level of fine is for breach of a duty that involves recklessness and a serious risk of harm. And there the company can go for 3 million, officers 600,000 or 5 years jail, workers 300,000 or 5 years jail. For a breach of a duty where it's serious harm or risk but no element of recklessness, company 1.5 million, officer 300,000 and worker 150. And for lower order breaches that don't involve a risk of serious harm or injury, 500,000 for the company, 100 for the officer and workers 50. So there's a range of penalties there, but you can see there's significant steps up on what exists. I won't go through that, but there is a, if you want to email me the activity sheet I have, which enables you to do a bit of a self-assessment of whether or not you can meet the due diligence requirements. It's based on compilation of a series of the guidance documents issued by Safe Work Australia, New South Wales and Queensland, which have put out guidance on that. And at that point I'll open up for questions. As I said, I'll send a copy of this through to Murray to distribute to you all.
No question, but Graham, on that one with that mobile vehicle, I happen to be working with the company who made the scanners at the time, and I wasn't the product manager, but there was a company actually, I think they closed down. They went into receivership, I think the company that supplied that particular machine.
Yes.
But they didn't re-examine the residual risk after they'd fitted the machine.
That's right.
And fitted the scanner.
Yes.
The residual risk was still there. It was still far too high, the
Yes.
opportunity to actually take that guy's foot off.
Yes.
And that's the thing that really got to me at the time. And
Yes.
I and my offsider were both dragged into workshops
Yes.
for a question and answer on that, and they just took one look at it and said, oh well, yeah, there's a residual risk.
Yep.
You know, that shear point as it came past the
Yes.
platform was never correctly addressed.
And the judge didn't understand hazard or risk, let alone residual risk.
Yes, yes. So that one stuck with me a little bit. I thought, how silly. But the crook part of it was, his wife was hit by the same machine working in the same company a couple of weeks earlier.
Yes.
But that was never taken into account.
And his son, in another one of those tragedies, his son was driving his car, and a few weeks before the court case came up, his son was in an accident and lost his legs.
Really?
Yeah. So when we got to court, that gentleman was in a very, very traumatic, emotional state. Yeah.
But the whole thing was silly, yes.
Yep. Murray, any questions you want to draw out, or?
No, look, I think you guys pretty much covered everything. Some of our main concerns, what we're seeing as industry, is where systems are being modified, altered, and hydraulic companies just doing hydraulics.
Yes.
It just seems to be a complete lack of understanding out there. In fact, there was over 20 hydraulic companies invited here today. There are 4 of those companies represented. 15 of them we never even heard from, didn't even acknowledge. So that seems to be the attitude out there these days. So, all right, I'd like to thank Jim and Graham for your time. It's been very interesting. And feel free to hang around, have another cuppa if you wanted. The cake and bickies are still out there, and yeah, grab these guys' cards if you ever need them one day. Yeah. Hopefully you won't. But
On a personal note, I've been a member of Graham's Forum for quite a few years now. If you're not a member, get on it. It's just a wealth of information that you can call on at any time, and it's free. Not like a lot of things these days, but you actually get some really good value out of it. And it's a point too, if you know about your stuff, you get often a chance to contribute to other people's questions. It's I think in this day and age, knowledge is king, and it's pretty hard to go past.
It's fantastic for getting a whole range of perspectives. I mean, I obviously have a legal one, but you see so many people with, and it's one of those things where there's no such thing as a dumb question, because people have different backgrounds and perspectives, and it's amazing how sometimes someone will ask a question. There's even a process for asking questions anonymously. If people feel too embarrassed, they just email me and I'll post a question without disclosing who asked it. And some of those questions which people are too embarrassed to ask flush out a lot of discussion and perspectives and issues that, when you stop and think about an issue, sometimes a lot more there than meets the eye.
all right, great. Thank you very much for that.